Okay. Ms. Fiore, Ms. Stahl, Ms. Connor, Mr. Brazel. How are people wishing to split their time?
Your Honor, this is Jessica Connor on behalf of Hart. I've agreed with my co-appellant that Hart will have the full 20 minutes of argument and Signal will stand on its briefs.
Okay, very well.
That's correct.
And Your Honor, this is Rob Brazel on behalf of Hillsborough County. I think I can make it easy on our side. We did not file a brief. We did not take a position on any of the issues below. We were more of a nominal party. We reiterate that position here. We don't take any position with respect to the issues here and stand ready to abide by whatever the ruling of the court might be.
Okay, very good. So the only ones arguing this morning are
Myself and,
Yep.
and Ms. Fiore.
and Ms. Fiore.
Yes.
That makes my life and my timekeeping much easier. Thank you very much. Okay, Ms. Connor,
Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal.
very well.
May it please the court. Jessica Connor on behalf of Appellant Hillsborough Regional Transit Authority, also known as HART, who is one of the defendants below. We're seeking reversal of the trial court's order entering a temporary injunction against HART and its vendor Signal. The order provides plaintiff Metropolitan Systems, Inc., who I'll refer to as Metro, the following 3 forms of temporary injunctive relief. First, the order enjoins HART and Signal from interfering with Metro's right to install ad benches. It also enjoins HART and Signal from installing any advertising benches in unincorporated Hillsborough County. And finally, it enjoins HART and Signal from dumping, dismantling, destroying, removing, or blocking Metro's benches. With regard to the first form of relief, enjoining interference with Metro's rights, Metro has conceded in its answer brief that this first form of relief is overbroad and therefore it must be summarily reversed. And I'll move on to the remaining 2 forms of relief, beginning with the portion of the injunction which broadly prohibits HART and Signal from removing plaintiff's benches under any and all circumstances, even when Metro's benches obstruct HART's ability to safely operate its bus stops and creates a dangerous condition in violation of the ADA on HART's concrete pads. HART and Metro are both authorized occupiers of the county's right-of-way. Metro owns and installs and maintains benches at bus stops within the county's right-of-way. Likewise, HART obtains permits from the county to build and construct and pays for the construction of concrete landing pads at bus stops, which HART constructs to comply with the ADA, which requires a bus stop to have a 5x8 boarding and a lighting zone.
So you're obviously speaking only for HART with regard to this injunction, because it seems really clear to me that HART struck a deal with Signal that HART didn't have the legal ability to strike. And so in terms of Metro's being successful on the merits, it looks really good for Metro based on what I've read. So your concern is about HART basically being able to do what it has to do in terms of the ADA and other things to make its shelters and things safe, but you're not suggesting that the injunction as to Signal is wrong. Am I right? I mean, you're only speaking for HART here.
Correct, Your Honor. I'm only
Okay.
speaking on behalf of HART, but the injunction entered against both of us is the same. And
Well, except for you have certain rights vis-a-vis the county. Signal has no rights as far as I can read this, because the only rights they have, you gave them, and you didn't have the authority to give them.
so whether or not the contract between HART and Signal, which authorized Signal to install ad benches, whether or not that contract is voided, it doesn't eviscerate HART's right to maintain its concrete
I'm not
pad.
arguing that. I just wanted to be clear. You're only talking about HART here because it seems like Signal is way out on the ice here.
Right. Signal doesn't have I don't think has a position with regard to removing benches from the pads
Okay.
because they're Hart's concrete pads. That's
But it
Hart's
seems
position.
like Signal's opposing the injunction, whereas the injunction seems extremely well taken as the Signal.
I can't really speak for Signal, but I can speak for
Well,
with
you
regard.
started this by saying you were, so
Oh,
that's
no,
why
no,
I'm asking.
I represent Hart, Your Honor.
I
and
know that, I get
Okay.
that, but you're the only one arguing here today.
Right,
Right.
Signal.
So I
wanted
can
to
only
stand up
ask
for
you questions about Signal because you're all I got.
Okay, I'll do my best to
Okay.
answer on behalf of Signal, but
All right,
I represent Hart, and Hart's position is Hart owns, pays for, constructs, and undertakes a duty to maintain the concrete pads. There's no evidence below that the county constructs those concrete pads, or just because the pads are in the right of way that somehow it becomes county property. Just as the fact that Metro places its benches in the county right of way doesn't now mean the county owns Metro's benches. Metro maintains ownership rights and a duty to maintain its benches within the right of way, just as Hart maintains ownership rights over the concrete pads that it pays for and it undertakes a duty to maintain. And because it undertakes a duty to maintain those pads, and that was undisputed, nobody else maintains those pads but Hart. Because it undertakes that duty, it has an obligation to make sure those pads conform to the ADA. But when Metro places its benches in the middle of those pads and obstructs passageway and obstructs the 5x8 zone, Hart is then put in a position where it's not correcting a dangerous condition or an illegal condition on its property. It has every right to remove the plaintiff's benches when they violate the ADA on Hart's property. And
Or
although
they could ask the county for ADA purposes to take
So-
care of it, because there's another contractual relation going on there.
So both the county and Hart could be responsible. If a disabled plaintiff wanted to sue the county because it's in the county's right of way, they could do that. But Hart wouldn't discharge its duty to properly maintain those concrete pads by merely saying, oh, this is the county's problem because the county owns the right of way. Hart undertakes a duty. It hires employees who specifically maintain those concrete pads.
So
And in
what did
doing
the
so, it
judge,
has-
what did the trial judge have before him as to the extent of what I'm hearing now is a prospective problem?
I'm sorry, I'm not sure what was the
Well,
problem?
you're anticipating all these problems, and I was just curious if there was any evidence before the trial court as to problems with the placement of benches and the need to remove or alter the position, and how extensive, if at all, that problem was.
We presented undisputed evidence that there were at least 86 bus stops where the plaintiff was placing their benches in violation of the ADA on the 5x8 pads. And the testimony was that in the past, before Metro came under new ownership, Hart used to ask Metro, please remove your benches from the ADA pads. And the testimony from Metro's representatives at the evidentiary hearing was that they would always comply with that. When they were told that they were obstructing the pad, they would then remove their benches. In 2019, Metro came under new ownership. And that since then, Metro has taken the position that it does not have to remove the benches from the pads. And therefore, merely asking Metro to comply with federal law and to remove its benches
Let me
has no
ask-
longer worked.
Excuse me, when you use the word pad, the pad includes the area for getting on and off the bus?
Correct. The
Okay.
concrete landing pad, typically a bus stop, it would just have a grassy area, maybe a sidewalk maintained by the county, and a bus stop sign that Hart installs. But Hart then goes in and gets permission from the county to install a large pad that has to be at least 5 feet by 8 feet.
Mhm.
It installs that and it usually connects to an adjoining sidewalk. And then from then on, Hart maintains that pad and has to keep it free of obstructions. And so although the plaintiff has a right to install its benches at bus stops, it's not an unlimited right. The plaintiff's own contract with the county clearly says no bench shall be permitted to obstruct passage along any public way. So the right to install advertising benches is it's not an unlimited right to completely enjoin Hart from removing their benches under any and all circumstances. Hart is not seeking a right to remove benches when they're completely placed in the grass in the county right of way, not interfering with or obstructing Hart's ability to operate its bus stop safely. Additionally, Hart has contractual rights where Hart's
So Ms.
shelters.
Connor, this idea of removing benches improperly placed, is this a perspective problem? Or in the trial court below, did you identify certain problems that exist right now? And if it's, I want to know what's in our record on this issue, somewhat like what Judge LaRose was asking. Did the trial court have before it below that there were certain benches right now that are a problem that need to be addressed?
Absolutely. The evidence presented to the court was that there were at least 86 Hart-operated bus stops with 86 Metro benches blocking the 5x8 boarding zones. In addition to that, the other problems created by the benches were that they were blocking the shelter ads. And Hart's contract and the plaintiff's contract says plaintiff's benches shall not obstruct Hart's shelter advertisements. And there was undisputed testimony and photographs showing numerous bus stops where plaintiff's benches visually obstruct and physically obstruct the public's access to the shelters, the trash cans, and Hart's other amenities. That there is definitely evidence in the record supporting all of those problems. And so the problem with the injunction is just it's overbroad. Clearly, Metro has certain rights at these bus stops, but so does Hart. And Hart's rights to safely operate its bus stops are clearly should be elevated above the private financial interests of a company to just advertise on benches. Hart is in charge of these bus stops. It maintains the bus stops. It should have the right to remove.
If I can ask a question, because you have made this argument in your briefs that the injunction is being overbroad. So are you challenging the injunction as being overbroad or challenging the injunction entirely?
With regard to the portion of the injunction enjoining removal of Metro's benches, we're challenging that as Metro didn't meet its burden to show a clear legal right to enjoin Hart to remove Metro's benches under any and all circumstances. And so because they didn't demonstrate a clear legal right to enjoin Hart in this manner, the injunction, it was an abuse of discretion to enjoin Hart from being able to at least remove benches under certain circumstances where it's shown it's being placed on Hart's concrete pads and obstructing passageway.
So your challenge is that not so much the injunction itself is just how it's been worded and how it's been packaged. Is that right?
Correct. Well, we're challenging the three forms of injunctive relief that were rendered against Hart. The first form has already been conceded to be overbroad and that it should be reversed.
Yeah.
And then we're challenging the injunction against installing, against Hart to install any advertising benches because Metro didn't prove that it would suffer irreparable harm if Hart wasn't enjoined during the pendency of this litigation from installing advertising benches. The testimony at the evidentiary hearing was that there was no ongoing controversy that Hart or Signal might start installing new advertising benches because 5 months before this lawsuit was filed, Signal had already agreed with plaintiff that Signal would not be installing any new advertising benches throughout this county until this issue was resolved.
They've only put down 15, right?
There was only 15 Signal
and
ad
only
benches.
one, and the last one was in like a year and a half ago, right?
Yes, Your Honor, I believe that the last time
19 or something like that.
2019 was the last time an ad bench was installed. So in terms of whether Metro was facing irreparable harm if an injunction against Hart and Signal from installing ad benches was going to occur, there was no irreparable harm threatened when it was a moot point because Hart and Signal had already agreed that they wouldn't install any more advertising benches. And also there was zero evidence that the fact that Signal and Hart had installed advertising benches at 15 locations, that there was no evidence that that ever stopped Metro from still advertising on benches. They just didn't show any harm by these 15 ad benches that have been installed. They never presented any evidence that they lost a client who refused to pay to lease ad space on their benches because Signal also had an ad bench. They never showed that they couldn't sell ad space on a bench because there was a Signal ad bench at the same bus stop. Our shelter, Hart shelters, have advertisements on them. So there definitely are 2 or more advertisers at these bus stop locations, and that is permissible under the contracts at issue. They simply never showed that they have ever been prevented from advertising on a bench because of the installation of Signal's ad benches, and therefore if they can't show harm, they certainly haven't shown irreparable harm. And with regard to the portion of the injunction enjoining Hart from dumping or dismantling or destroying plaintiff's benches, this was a clear abuse of discretion because there was zero evidence that Hart had ever done those things in the past. And the trial court's order recognizes the complete lack of evidence against Hart that it ever destroyed or damaged one of the plaintiff's benches, because the court, recognizing there was no evidence, says in the order, it matters little who is responsible for past transgressions. It absolutely matters who is responsible for past transgressions. It's an abuse of discretion to enjoin Hart from doing something that it never did in the past and that it has never threatened to do in the future. Hart has never taken the position that it will destroy one of plaintiff's benches. In fact, the evidence showed that Hart directed Signal not to damage any of the plaintiff's benches at any time. So there simply is no evidence in support of this injunctive relief. The plaintiff did not show a clear legal right to this injunctive relief. And the injunction must be reversed in its entirety. And on top of that,
Ms. Connor, if I may interrupt you for a moment, you're a little bit over 15 minutes right now, but it's your time. Use it as you wish.
I would like to reserve time for 5 minutes for rebuttal, Your Honor. Thank you.
Okay, very well. Thank you, Ms. Connor. Ms. Fiore.
Hi, Your Honors. Good afternoon. May it please the court. I'm Kristen Fiore here today on behalf of the Applee Metropolitan Systems, which I'll refer to as Metro for shorthand. Before I get into our arguments, I just want to touch on what is the main issue in this case that Judge Morris touched on in the very beginning. There is a long line of case law that says that injunctive relief is available where a government commits an ultra vires act. And that's exactly what happened, a government entity. That's exactly what happened here. And that is not addressed at all in Hart or Signal's brief. And if you look closely at the case law in those cases, it appears almost as if irreparable harm is presumed. If you interfere with someone's contract rights with a government entity, and you can look at the Hathaway case from the Florida Supreme Court, the City of Miami case from the 3rd DCA, there's a long line of cases that say the mere entry of this Hart Signal amendment in 2018 was a void act, and therefore injunctive relief is appropriate. So the inquiry can really stop there. But I do want to address the 2 main points that Hart and Signal focus on, because you know, we view these as, for lack of a better term, red herrings, because they divert from the clear state in this case that there was an ultra vires act and it should end there. Injunctive relief was appropriate. Regarding the ADA, so now if you look closely at the parties at the Hart and Signal's brief, most of, if not all, of their reply brief and initial brief arguments regarding the ADA factor into 2A of the injunction order, which my client has already conceded is overbroad. And so a lot of that argument moots any ADA concerns. However, in the event there still remains a concern, the clear solution to Hart's concern and their purported dilemma is in the statute itself, 337-408, which provides that counties and municipalities are required to comply with the ADA and other applicable laws or rules. As counsel mentioned, in the past, Hart has asked Metro to remove benches that it perceived as being violative of various regulations, including the ADA. And Hart's own witness, Mr. Rodriguez, at page 1139 of the appendix in the evidentiary hearing, he testified unequivocally when Hart has requested that Metro remove non-ADA benches or benches blocking ads on shelters, quote, Metro has complied. And he, quote, had no issues with Metro removing the benches. And curiously, he admits that in many cases, sometimes a landscaper moves Metro's bench, that they're not fixed to the concrete pad. And so it's impossible to know whether Metro placed the bench in a non-ADA compliant way or whether a third party came in and did so. And
but the way this injunction, the language of this injunction, if that were the case, and if that scenario happened now after the injunction, removing the bench, if it violated the ADA, was in violative of the ADA here, that would be a violation of the injunction. Would you not agree?
We suggest that you're referring to 2C of the injunction order.
Well, if you look at, the past facts that have happened in this case where they've requested that Metro remove it, and let's say they didn't, and they went ahead and moved it, then the actual removing of their benches, even though it was in violation of the ADA here, would violate the injunction.
I would argue that the injunction does not prohibit them from, quote, moving a bench. The benches are their own.
But given the way that it's drafted and it doesn't address the ADA, by just looking at the language, that is violative of the injunction. So no, but I can't imagine that they're going to do that and risk that and be in violation of it.
And I understand that. I would suggest that in this case, they had an opportunity, and I do mention this in the brief, that to the extent they were concerned about the ADA implications of the injunction, they had a duty to bring that to the trial court's attention. And I know that in their reply brief, they say, well, that's only a duty when we have a final judgment. And I was citing a case as an example that what is the practice in a non-final appeal is if you get an order, you have 30 days to appeal it. And what is the practice is you promptly, if you have any problems with the order or any confusion or lack of clarity, that you immediately, as promptly as possible, file a motion for reconsideration.
Sure.
And if the court if you cannot obtain a ruling on that, before you file your notice of appeal, you file your notice of appeal and then you ask this court to relinquish jurisdiction.
Sure, and I suppose the counter to that is one would look at this and say, well, if you look at the language of 2A, interfering with Metro's priority right, that's a defined right under the language of their contract with the county. And therefore, to the extent Metro priority is exceeding, Metro is exceeding their priority right, then I guess that wouldn't be an interference, then would it?
Right, and we concede that A, which is the sub part of the order that you've cited, we concede that's overbroad.
That's overbroad.
Yes,
right.
so we're not here arguing about that particular provision. We concede interference is too broad, but we stand on our arguments as to the other two provisions. And I just want to get to the concrete pads briefly. If you look at the evidentiary hearing, Hart presented no evidence that it has property right in the pads. Both the county attorney and Hart's employee Rodriguez confirmed that the county owns the right of way where the concrete pads are located. And so Hart relies on the county Hart contract, which says that Hart has a property interest in Hart, quote, shelters and, quote, any amenities thereto as described in section 337-408. Hart takes the position that its pads are amenities under the statute, but nothing in the statute says that. It doesn't even discuss concrete pads. And again, had they had a question about the ownership of the pads, they should have asked the court to make a determination factually as to who owned the pads. And one important thing is if you look at the testimony, again, I encourage you to read the testimony of Hart's witness, Mr. Rodriguez. at appendix 1145 to 1146, when he is asked about the concrete pads and who owns them, he suggests that they belong to the county in a way. He says, quote, "It belongs to the county because it's the owner. The right-of-way belongs to the county, and quote, I'm a tenant in the right-of-way." And so I just want to make that point with the concrete pads. And I also want to, real quick, regarding the harm that Metro did not satisfy the irreparable harm element, I would revert back to the argument that the case law that says that when a government entity enters into an agreement that's ultra vires, that is harm in and of itself. However,
Go ahead.
go ahead. No, go ahead, Your Honor.
Well, I was focusing on looking at C and the language of removing the benches. And Ms. Connor has stated that, has argued here that there was no evidence that Hart removed the benches, and therefore that language is all overbroad in the injunction. What is your response to that?
Well, my response is, again, back to the argument about the agreement itself, and nothing prohibits them from doing that in the future. And as a matter of fact, I think it's important to look at the agreement between my client and the county. There's a sunset provision in that agreement, and it basically sunsets in 2022. And at that point, one of my client's competitors, Signal, will have a competitive advantage regarding putting all these benches in and removing our benches that it never had the authority to have to begin with. And then we will be left at that point without the ability to do anything about it. And I will tell you that this case is, even though this is a 2-year-old case.
But that's a future event.
Right. And I would say that future harm, that's the purpose of an injunction. If you look at the Heavener case that we cite, and
but the purpose of an injunction is to maintain the status quo.
Correct. In the Gawker case that this court issued, Gawker Media, I believe is the name, the whole purpose is to keep the status quo in place so that, the court can figure out what are the rights of the parties. And here we are left, we're still in the infancy really of a 2-year litigation, because we're only at the temporary injunction stage, and so much can happen to my client's business and
there's nothing that would prevent your client from coming back if that were the case, and then seeking to extend the injunction to cover additional activity.
Yes, but we submit that's not necessary because of the existence of the agreement that allows them to do any of this in the first place, that they have entered into, and that in and of itself is the harm that we're trying to prevent.
But you're saying that with Signal.
Well, no, Hart as well. I mean, we
Okay.
don't have a way of knowing, we submit that there's a myriad of things that frankly, the evidence that was submitted by Hart, this list of 86, the trial exhibit itself does not appear in the appendix. From what I can tell, it's only what was attached to their temporary injunction documents. So if it was the same exhibit that was admitted, and we don't have a way of knowing because it's not in the appendix, it's not authenticated. It's just a list of, it says non-ADA compliant. We don't know who did it, who put the bench there, who may have moved the bench. So we submit that for now, that this is the best way to protect our clients' rights going forward. And just to summarize, I mean, I've really said, what I wanted to say is that what happened here is a quasi-governmental entity gave away a right it had no authority to give away. I've cited a litany of cases that say injunctive relief is absolutely appropriate in those circumstances. Irreparable harm is basically presumed. And when you look at the public interest element piece, there's a Florida law, there's a Telemundo case from the 3rd DCA, says that the public has an interest in protecting and enforcing contract rights. And clearly, as is stated in both agreements between the parties here, the maintenance of a public seating service certainly benefits the public. And our client, Mr. Gray, testified that Metro stands ready to invest $3 million in public seating infrastructure in Hillsborough, in the unincorporated parts of Hillsborough County, but can't do so because of the uncertainty created by the Hart Signal amendment that was void. Nor can Metro further develop and build its business while this cloud of uncertainty created by Hart continues to exist. And so for those reasons and the reasons stated in Metro's brief, we ask that you affirm the injunction order with the exception of paragraph 2A. Thank you.
Thank you, Ms. Fiore. Ms. Connor, rebuttal?
Thank you. The plaintiff argues that Hart failed to prove that it owned the concrete benches. To the contrary, the plaintiff had the burden to prove a clear legal right to the injunctive relief that was provided by the trial court. Plaintiff had to prove that Hart could be enjoined from removing the plaintiff's benches. So plaintiff had to prove Hart didn't own the concrete pads. All of the evidence that was presented in the evidentiary hearing was that Hart does own the concrete pads, and evidence that the county owns the right-of-way simply isn't evidence that the county owns the pads. It wasn't sufficient evidence. There are a variety of authorized occupiers of a right-of-way. It could be a utility company, it could be the plaintiff's benches. None of those, the property of those different entities becomes county property by virtue of installing items in the right-of-way. Hart's project manager clearly testified during the hearing that there were a number of ADA violations presently occurring at the time of the hearing. He went through that. We went through all of the exhibits and all the photographs showing that, and he testified to that. So there is evidence in the record of the ADA violations. He testified that the county is virtually a landlord because it owns the dirt, but Hart and the plaintiff are akin to tenants because they occupy and possess and control portions of the right-of-way with the county's authorization. Along with the occupying and the control and the possession of property comes a duty to maintain. And all Hart is seeking here is that it be permitted to comply with its legal common law obligations as a possessor of property to maintain that property in a safe condition. And so all it's seeking is that it be permitted when circumstances require it to take action, that it not be required to sit back and merely request and beg the plaintiff, please comply with federal law, please stop obstructing our concrete benches with your advertising benches. It doesn't have to sit back and wait for that to happen. And what was proven at the hearing was that those requests were made in the past, they were complied with in the past, and they're no longer being complied with. And Metro filed this lawsuit to prevent Hart from being able to take any action to remove those benches because the plaintiff doesn't want to pay the cost to install their own concrete pads to be ADA compliant. They want to trespass and utilize without any payment to Hart and subject Hart to liability without any indemnification contract. Hart doesn't have a contract with the plaintiff. So when Hart gets sued because of the actions of Metro on Hart's concrete benches, there is no contract in place that requires the plaintiff to indemnify Hart. Hart has a legal obligation and a right to maintain its pads in a safe condition. The court didn't enter any factual findings finding that Hart doesn't own these concrete pads. The court acknowledged that a dispute over the pads exists. The order says Hart argues it owns the pads. The end. The court doesn't say it agrees with Hart that Hart owns the pads, and the court didn't make a factual finding that it disagrees that Hart owns the pads before granting overbroad injunctive relief against Hart. The case law states the entry of a temporary injunction will not stand unless the trial court makes specific findings in support of each and every element required for the entry of the injunction. The court did not resolve this issue whatsoever with regard to the ADA issues and Hart's ability to maintain its right to maintain its concrete pads. It didn't address it at all. It focused solely on the fact that it found that Hart doesn't have a right to install advertising benches. But the fact that Hart doesn't have a right to install advertising benches doesn't mean it also doesn't have a right to maintain its own property when the undisputed evidence was that the pads are in fact Hart's property. And even if it wasn't Hart's property, it undertakes a duty to maintain them. It needs to be able to do exactly that without violating an injunction, the injunction order. And with that, we would request that the temporary injunctive relief that was provided to the plaintiff be reversed in its entirety because Sufficient factual findings were not made. Plaintiff did not demonstrate a clear legal right to this overbroad relief, which it has already agreed is overbroad, at least in part. Thank you.
Thank you, Ms. Connor. Thank you both. Very well argued, interesting case. That concludes our docket for this morning, actually into the afternoon. So we are adjourned. Thank you all.